We are gonna try.
Mr. Chair, I don't see any of the Republicans yet.
I'm not going to start until they get here. I see their names, I just don't see their faces. And I'm going to ask committee members to turn on their cameras when they come back from their caucuses so that we can have a quorum established for this session. 1, 2, 3, 4, 5, 6, we do. So welcome back to the Joint Standing Committee on Labor and Housing. Everyone, interested parties, bill sponsors, the public, and everyone else. We have lined up, I believe, if I can count correctly, 12 work sessions today. We are going to begin with LD 1489, and then we are going to go in numerical order from top to bottom. So that's the only bill we'll be taking out of order is LD 1489. And with that, I will open the work session on LD 1489 and act to update the classification of service employees presented by Representative Scott Cuddy of Winterport. Mr. Langland, please present the analysis.
Sure. So this bill increases the amount of tips an employee must receive to be considered a service employee from $30 per month to $175 per month, and provides that this amount, beginning on January 1st of next year, be increased by the same percentage of the increase, if any, in the cost of living, similar to the minimum wage law now. The committee heard testimony from Hospitality Maine that the group prefers less of an increase or more of a gradual increase over time. If the bill is enacted, they request that the Department of Labor communicate the change extensively with restaurant licensees to ensure they're not in non-compliance due to lack of knowledge about the change. The Maine Policy Institute testified that the bill would require businesses who have built their business models around the tip credit to incur expenses due to the higher threshold of what constitutes a service employee. The Maine Tourism Association testified that it's not clear what this bill seeks to address. Current threshold of $30 per month covers all servers, and so employers know how to classify their employees. The bill would make tracking and classifying employees difficult, as it could change month to month or even during the month. The Maine AFL-CIO testified that the $30 threshold has remained unchanged for 50 years, and that the $175 threshold change will appropriately recognize the role the workers play in the state's economy. The Maine Center for Economic Policy testified that it estimates 1 in 7 Mainers receive less than $175 per month in tips, and that it would raise take-home pay for Mainers by an average of 33% or $58 per week. The department testified that an increase from $30 to $175 is large, but estimate that it won't significantly affect many workers, as most employees classified as service employees earn over $175 a month in tips. They also testified that it's likely to affect part-time workers or those who work few hours in a service occupation. They also note most states with a tip credit mirror the $30 threshold found in the Fair Labor Standards Act, which is a federal law. Vermont is the exception, which has $120 per month threshold. They said they don't anticipate any enforcement problems if the bill is to move forward. Some additional information, the minimum wage and the employer tip credit can be found in Title 26, Section 664, subsection 2. It states that an employer can consider tips as part of the wages of a service employee, but a tip credit cannot exceed 50% of the minimum hourly wage established in this section. So that's currently $6.08. It also says that an employer must be able to show that the employee receives at least the minimum hourly wage when direct wages and the tip credit are combined within the established 7-day work week. And the employer shall increase the direct wages by the difference. And I did include a reference to what I described above. The Fair Labor Standards Act defines employee as any employee engaged in an occupation in which he customarily and regularly receives more than $30 a month in tips. The committee has not yet received a preliminary fiscal impact statement.
Thank you, Mr. Langland. Let's see, discussion amongst the committee. Representative Cuddy, do you have anything to say?
I do, yeah, thank you, Senator Hickman. So in listening to the testimony and taking that into account, I do want to propose to amend the bill slightly. And in terms of the timing on the amendment, I'm never sure how fiscal year versus regular year, and Mr. Langland and I can maybe have a discussion about it. But what I would want to do would be to have in the year following passage of the bill, the tipped amount would go from $30 to $100. And then in the year following that, the amount would go from $100 to $175. And thereafter, it would go up by the CPIW, which I think is what we had in the bill. Yeah, CPIW would be the increasing factor in the year following. So in the first year, it would go up to 100. The second year would go up to 175. The third year would just increase by whatever CPIW was. And for sake of simplicity, I would like it to be a January 1st date of each year, so that it's not changing in the middle of a month as some of the folks were concerned about.
So Representative Cuddy, are you officially presenting that as an amendment, a motion, an amendment and a motion?
Yeah, I would, if it's appropriate at this time, I would like to make a motion to pass the bill as amended with the amendment that I've just spelled out.
Representative Cuddy has moved, ought to pass as amended. Is there a second? Seconded by Representative Gear. Is there any discussion from the committee on the motion? I do not see any hands raised, but of course my participant screen is not right. Oh, there we go. Chairman Sylvester.
I just wanted to say, thank you to Representative Cuddy for bringing this bill forward. I thought, that your response to the testimony, particularly the testimony of Mr. Dougal, this is a good amendment to try to follow, the recommendations that he had given, and I'll definitely be supporting this bill.
Thank you, Representative Sylvester. Mr. Chairman, anyone else want to discuss this motion, ask any questions? Therefore, the committee looks like it's ready for the question. Ms. Thompson, please call the roll. The motion is ought to pass as amended on LD 1489.
Senator Hickman.
Yay.
Hickman, yay. Senator Guerin.
No.
Guerin, no. Senator Miramont. Senator Miramont's absent. Representative Sylvester.
Yay.
Sylvester, yay. Representative Bradstreet is absent. Representative Cuddy.
Yes.
Cuddy, yes. Representative Drinkwater.
Nay.
Drinkwater, nay. Representative Gear.
Yes.
Gear, yes. Representative Morris.
No.
Morris, no. Representative Pebworth.
Yes.
Pebworth, yes. Representative Prescott is absent. Representative Rader.
Yes.
Rader, yes. And Representative Warren.
Yes.
Warren, yes. That is 7-3 with 3 absent.
7 members voting in favor of the motion, 3 opposed, and 2 absent. The motion prevails. What is the minority report?
Ought not to pass.
Aaron, ought not to pass. It is. I will close the work session on LD 1489. We will now open the work session on LD 151, an act to protect farm workers by allowing them to organize for the purpose of collective bargaining, presented by Representative Tom Harnett of Gardner. Mr. Langland, please present the analysis.
So this bill, if you recall, was a concept draft when it was initially came to the committee. At the public hearing, Representative Harnett did propose an amendment. The amendment gives employees of agriculture employers the right to bargain collectively. It specifies the parties' mutual obligation to bargain, creates procedures for determining bargaining units and bargaining agents, including procedures for appeal of such determinations, and prohibits specified acts of agricultural employers and agricultural labor organizations, and provides for enforcement of those prohibitions by the Maine Labor Relations Board and subsequently through civil action in Superior Court. The bill is structured similar to Maine's other collective bargaining statutes. There are 4: municipal, state employee, humane system, and judicial. The sponsor amendment that was presented at public hearing is largely unchanged from what was Title 26, Chapter 16, which was the Agricultural Employees Labor Relations Act, and it was repealed in 2011. The major difference between the repeal and what the sponsor proposed at the public hearing was that it specifies that an agricultural employer is a person or entity that employs more than 5 agricultural employees. And I did include some select statutes. They mostly mirror, as I said, the language that's in the other collective bargaining statutes that are in the main revised statutes. I would note, so as I said earlier, the process by which disputes are adjudicated is through MLRB, which is similar to how disputes are processed and filed via the state's 4 collective bargaining statutes. Representative Harnett did contact me to draft an amendment that allows for the inclusion of majority sign up in the collective bargaining statute. So it's similar language that's already in the Municipal Public Employees Labor Relations Law. So what happens is if a request by an ag employee organization for recognition is not granted by the agricultural employer, the executive director shall examine the demonstration of support. And if they find a majority of the employees in a unit appropriate for bargaining have signed valid authorizations, what happens then is the board can designate that bargaining unit as official for those employees that have signed up, if a majority of them sign up. So my understanding in talking with Representative Harnett was the intent was efficiency and administrative burden on the Maine Labor Relations Board. And I know that Neil Daly is here and he could probably speak to that a bit more. So I did include a little bit of information on the prior Maine law. So as I said, this is largely what was repealed in 2011, but it was first enacted in 1997. The old law applied to employers operating an egg processing facility that had over 500,000 laying birds and that employs more than 100 agricultural employees. So Representative Harnett's bill stipulates that it applies if a farm employs more than 5 agricultural employees, but there is no provision in his amendment that he presented for laying birds. So after the bill was repealed in the law was repealed in 2011, there was a directive to the Department of Labor to sort of study the impact of that repeal and to submit a report back to the Committee of Jurisdiction, which at that time was the Labor, Commerce, Research, and Economic Development Committee, also known as LCRED. And the report said that at that time there was no need for any further legislation, but LCRED was authorized to report out a bill, but the report did not recommend any inkling to do so. So federally, the Migrant and Seasonal Ag Worker Protection Act establishes employment standards related to wages, housing, transportation, disclosures, and record keeping. And it also requires farm labor contractors to register with the U.S. Department of Labor. The committee has not yet received a preliminary fiscal impact statement, probably largely given that it was a concept draft. I'm happy to try to answer any questions. And like I said, Neil Daly is here. So if you're looking for very specific nuts and bolts on how the collective bargaining statutes work, I would most likely defer to him. I don't know if Representative Harnett, oh, he is in the room. Okay, so he could probably speak to his proposed amendment, and I'm happy to try to answer any questions as well.
Thank you, Mr. Langland. Seeing that the bill sponsor is here and would like for us to consider his amendment, Representative Harnett, the floor is yours.
Thank you very much, Senator Hickman, Representative Sylvester, members of the committee. As your analyst who was very helpful on this aptly pointed out, I submitted this amendment under based on a suggestion from Executive Director Neil Daly of the Maine Labor Relations Board. This is a more recent change in their the way they handle elections and unit certification. And it was his suggestion that it would lessen the cost incurred by the Maine Labor Relations Board and would lessen the administrative burden placed on its employees So knowing how we are all concerned with the fiscal impact of bills, I took him up on his suggestion. I don't want to put words in his mouth, but I did share with your analyst his thoughts that he shared with me in an email, and that's the reason for the amendment.
Thank you, Representative Harnett. Are there any questions for the bill sponsor about his amendment from the committee? Seeing none, any questions for Mr. Neil Daly from the committee? Chairman Sylvester.
I just wanted to hear briefly from Mr. Daly on his thoughts on Representative Harnett's, just so that the committee could be clear.
Thank you. Mr. Daly, please introduce yourself.
Well, good afternoon, everybody. I'm Neil Daly. I'm the Executive Director of the Maine Labor Relations Board. And yeah, just to follow up in terms of what Representative Harnett explained, as well as Mr. Langland. Following the public hearing, I did email Representative Harnett to suggest potentially amending LD 151 to provide for the certification of a bargaining agent through the majority sign-up process. As most of you are likely aware, majority sign-up was enacted by the previous legislative session for the municipal public employee labor relations law. And in basically about a year it's been in effect, I found it to be, pretty efficient process. So rather than, potentially conducting an on-site or mail ballot election, basically a union will submit signed authorization cards from employees, and ultimately, if a majority of employees from a proposed bargaining unit have authorized a union to serve as their designated agent for the purposes of collective bargaining, then we go ahead and certify the union. Of course, we also provide the employer the ability to respond if there's potential objections about the scope of the proposed bargaining unit, or questions about the accuracy of the cards. But again, ultimately, I've found it to be a pretty efficient process since it's come into effect.
Thank you, Mr. Daly. Are there any questions for the Director of the National Relations Board? What happened to my mic? Can you hear me?
Mm-hmm.
Okay, great. Senator Miramont.
Has a motion been made?
No, sir.
I'd like to move ought to pass as amended on LD 151, please.
It's been moved ought to pass as amended by Senator Miramont. Is there a second? It's been seconded by Representative Scott Cuddy. So the motion is ought to pass as amended with both the bill sponsors' amendments, the one presented at the public hearing and the one presented today. Is that the correct motion? Any discussion from the committee on the motion before us? Representative Rader.
Thank you so much, Mr. Chair. I just wanted to take a moment before we vote on this to address something that troubled me when we were discussing this farm workers bill and the farm workers bill regarding minimum wage. So thank you for indulging me. There was some sort of racially coded language that was used, and I wanted to take this time to apologize to the public for hearing that. And I know that nobody on this committee would ever want to appear racist or be thought of as racist. So I just want to encourage us to think about our language as we go forward, specifically when we're talking about people that have come to our state to work in the farms, that we have heard from the farmers are valued and beloved members of their beloved employees. So that's what I wanted to say on that. Thank you.
Thank you, Representative Rader. Representative Morris.
Yes, thank you, Mr. Chair. I will be opposing this motion. I strongly oppose this bill, coming from the community that I come from and from the family that I come from. My grandmother grew up on a farm in Turner, and those farms are no longer there. These farms are disappearing. It is, this is not going to help with that. It is not the reason that they are exempted from this is because it is not practicable to be able to have unionizing of farm workers. Most farmers that I know in my area are working side by side with their workers every single day. And to be put in a position now where they would have to worry about potentially having workers going on strike at the height of their season when they're trying to get their crop in becomes very problematic, and very problematic for farms going forward and farmers in this state. So for those reasons, I will be opposing this motion.
Thank you, Representative Morris. Representative Chairman Sylvester.
Thank you, Mr. Chair. I just wanted for the public who might be listening to go through a little of the history of this bill. This bill was presented in the 129th, and we heard a vigorous discussion on that day and that hearing of concerns from farmers, mostly of the fact that they had not had a chance to weigh in. And so at that time, we did kill this bill, and we put together a group of farm workers and farm worker advocates brought together by the Department of Labor. We had a vigorous discussion on both this and the bill of employee status. And what I can tell you is that the group was pretty unanimous in having concerns about employee status, but that on this bill, including a group that included the potato farmers, the Dairy Association, and several small farmers, that they were not concerned about this bill. This was not a bill that was giving them a lot of heartburn. And so I take that as a statement, that farmers know how to work together with folks and to see what the root of the problems are. No pun intended. Well, maybe pun intended. And that that this bill advocates that farmer workers have worth, and and I appreciated the conversation that day, and I just wanted to make sure that folks knew that. Thank you.
Thank you, Chairman Sylvester. Senator Guerin.
Thank you, Mr. Chair. Representing one of the highest farm districts in the state, highest per capita farmers, I guess maybe you'd say, I would beg to differ with my good friend from Southern Maine. I know there is widespread opposition to this bill in the farm community, and for that reason, I will be voting ought not to pass.
Thank you, Senator Guerin. Representative Morris. You're on mute, sir.
Thank you, Mr. Chairman. I would say I spoke with the Farm Bureau as well, and as I understand it, there was one discussion. There was no real consensus around this piece, and that they remain opposed, as do many of the farmers in my district, as they do in Senator Guerin's district.
Thank you, Representative. Senator Miramont.
Thank you, Mr. Chair. The representative brought up Turner in this discussion, and it put right into my mind, but one of the biggest reasons why I would like to have this. They never need to use it if a company's treating them well, but DeCoster is a great example. And I don't know for new legislators, if you've ever heard of the word DeCoster egg farms, but when something is horrible as the way they were treating people and their animals was discovered, they don't rush to fix that. They rush to make sure that it's criminalized, that you bring a camera in to uncover this sort of thing. So to allow a way for the workers to stand up to really bad management, and I mean really bad, is just something I feel I have to do and support. Thank you.
Thank you, Senator. Representative Drinkwater.
Thank you, Mr. Chair. I guess I'm going to have to point out that we heard from a tremendous amount of farmers: Harry Ricker, Ralph Caldwell, Don Flammery from the Maine Potatoes Growing Association. In fact, we even heard from the good Senator Chair's neighbor that they have a right to organize. DeCosta farm was taken care of. The system does work. It may not be perfect, but it works. And for proof of that, we saw the Maine Tomato, I think that's in Madison, pay a $250,000 fine. So the system works as we have. So therefore, Mr. Chair, I am going to have to oppose this.
Thank you, Representative. And just for the point of clarity, my neighbor actually did not testify against this bill. He testified against LD 1022, which would be to reclassify employees, farm workers as employees, but the point is taken. Senator Garrett.
I'm sorry I left my hand up, but if you would allow me another comment, I would take it.
Go for it.
One thing I meant to say about the dairy farmers in my district, if a strike was held on a dairy farm, the infections for the cows not being milked that would wipe a farm out in a week. So really just, this would be drastically bad for farmers. Thank you.
Senator Miramont.
Thank you, Mr. Chair. And I just wanted to put this out for not just this work session. And it may need to be updated by our Department of Labor folks, but until the pandemic, the fastest growing business was farming. We used to farm 6 million acres in this state. We're less than 1 million now, but the fastest growing industry was young farmers coming in. It was mostly organic. And I'm grateful for an update, but to keep hearing that farms are going away, farms are changing and needed to in some cases. And you're a prime example, Mr. Chair.
Thank you, Senator. I couldn't agree with that statement more. Representative Warren.
I also have a statement on the bill, if I could.
You are recognized.
Okay, thank you. I just wanted to say, to speak a little bit further into the history of this bill in the way that Representative Sylvester did. I know this was a subject in the public hearing, but I just wanted to affirm my principles on it, just in that the reason that this class of working people was excluded was the legacy of the enslavement of Black and Brown people in this country. And this bill will simply have Maine law recognize this class of working people like all others who already have the right to collectively bargain. So if that's the reason that they were ever not included, this would be a rectifying of that structural racism in a much longer history. And I think to quote something that Representative Harnett, I believe, said during this hearing, it's nothing more and nothing less than that. So it's just equality under the law, and our laws ought to provide for that equality. In this case, they did not. We are simply correcting a horrific error of our own history, and it is only right. And to me, it is just that simple.
Thank you, Representative Warren. Any other discussion from the committee? I want to just say one or two things briefly. First, I just want to share a piece of testimony that we didn't actually hear during the public hearing, but was filed for this bill. In particular, it comes from the Attorney General of the state of Maine, and I will just briefly quote it. I strongly support the right of workers to organize, form and join unions, and to collectively bargain. The decision on whether to unionize should always belong to the workers. Numerous studies have shown that increased unionization lifts up all workers, whether they belong to unions or not, in the form of higher pay and more robust benefits. Thus, supporting the labor movement is supporting the strengthening of the dignity of work. Agricultural workers historically have faced numerous obstacles in their struggle to win greater dignity in the workplace. One is that under current law, they are not protected by minimum wage or overtime laws. Another has been their exclusion from the National Labor Relations Act. The lack of minimum wage or overtime protections and the exclusion from the NLRA, which typically would preempt state laws on a variety of collective bargaining and union issues, makes LD 151 necessary. The exclusion of agricultural workers from the NLRA is also what makes LD 151 legally valid, as the bill would not be vulnerable to a challenge on preemption grounds. I strongly encourage the committee to support this important bill. I also want to say, as a farmer who lives in a district with a lot of farmers, that farms in Maine are of all different shapes and sizes. And while I have not been able to talk to every single farmer yet in my district about these bills that affect what we do, the ones I have spoken to have actually not been in opposition to this particular bill and have made it very clear to me that they would support whatever vote I took, because they understand that I'm all about equality and going after the foundations of institutional and structural racism in this country, especially as it applies to farm workers. What is good for farm workers is good for farmers. Farmers may someday be farm workers if they already haven't been. And we know that if our employers and our farms that we work on and where we employ people to work with us, our family, and we treat everybody like family, and we treat them well, I see no threat that there will ever be the need for a strike if the farmers organize in the first place, which may not ever happen, as it did not happen when this law was currently on the books. So just because it didn't happen doesn't mean the law isn't good state policy, especially as it comes to going right after pulling up those rhizomes of racism that sprout up wherever they sprout up. So with that, I will support the motion. Ms. Thompson, will you please call the roll?
Senator Hickman.
Yay.
Hickman, yay. Senator Guerin.
No.
Guerin, no. Senator Miramont.
Yay.
Miramont, yay. Representative Sylvester.
Yay.
Sylvester, yay. Representative Bradstreet is absent. Representative Cuddy.
Yes.
Cuddy, yes. Representative Drinkwater.
No.
Drinkwater, no. Representative Gear.
Yes.
Gear, yes. Representative Morris.
No.
Morris, no. Representative Pebworth.
Yes.
Pebworth, yes. Representative Prescott is absent. Representative Rader.
Yes.
Rader, yes. And Representative Warren.
Yes.
Warren, yes. That is 8-3 with 2 absent.
8 members voting in favor of the motion, 3 opposed with 2 absent. The motion prevails. What is the minority report?
Ought not to pass.
Ought not to pass it is. I will close the work session on LD 151. Thank you, Representative Harnett, for your work on this issue as always. I will now open the work session on LD 225, an act regarding the treatment of vacation time upon the cessation of employment, presented by Representative Amy Rader of Bangor and Mr. Bangor and Mr. Langland. If you would defer, please. The bill sponsor has something to say about this bill. Thank you.
Thank you. I shouldn't have clicked my raise hand. I knew you were on top of it, Mr. Chair. I would request that this bill be carried over, please.
So would you like to make that as a motion?
I would like to make that as a motion, please.
So it's been moved that we request this bill be carried over. Is there a second? It's been moved by Representative Rader and seconded by Senator Miramont. Is there any discussion on the motion? Ms. Thompson, if you are ready, please call the roll.
Senator Hickman.
Yay.
Hickman, yay. Senator Guerin.
No.
Guerin, no. Senator Miramont.
Yay.
Miramont, yay. Representative Sylvester.
Yay.
Sylvester, yay. Representative Bradstreet is absent. Representative Cuddy.
Yes.
Cuddy, yes. Representative Drinkwater.
Nay.
Drinkwater, nay. Representative Gear.
Yes.
Gear, yes. Representative Morris.
No.
Morris, no. Representative Pebworth.
Yes.
Pebworth, yes. Representative Prescott is absent. Representative Rader.
Yes.
Rader, yes. And Representative Warren.
Yes.
Warren, yes. 8-3 with 2 absent.
8 in the affirmative, 3 in the negative with 2 absent. The motion prevails. The committee will request a carryover to the presiding officers of LD 225. I will close the work session therefore on that. Open the work session on LD 447 and act to require equivalent paid parental leave for all parents employed by companies offering paid parental leave, sponsored by Representative Amy Rader of Bangor. And Mr. Lane, please defer. The bill sponsor has something to say.
I'm making people's days a little bit shorter here, and I will take payment in candy. Thank you so much. I would request and make a motion that we table this bill indefinitely. There is better legislation coming along that addresses these issues more completely.
So your motion would be ought not to pass?
Yes, correct.
Moved ought not to pass. Is there a second? Seconded by Senator Miramont. Any discussion of the motion? Seeing none. Whenever you are ready, Ms. Thompson, please call the roll.
Senator Hickman.
Yay.
Hickman, yay. Senator Guerin.
Yes.
Guerin, yes. Senator Miramont.
Yay.
Miramont, yay. Representative Sylvester.
Yay.
Sylvester, yay. Representative Bradstreet is absent. Representative Cuddy.
Yes.
Cuddy, yes. Representative Drinkwater.
Yay.
Drinkwater, yay. Representative Gear.
Yes.
Gear, yes. Representative Morris.
Yes.
Morris, yes. Representative Pebworth.
Yes.
Pebworth, yes. Representative Prescott is absent. Representative Rader.
Yes.
Rader, yes. And Representative Warren.
Yes.
Warren, yes. That is unanimous of those present.
The motion is unanimous of those present. The motion prevails. That bill will go into the dustbin of history. I will close the work session on LD 447. I will now open the work session on LD 473, an act to create the main rental assistance and voucher guarantee program presented by Representative Victoria Morales of South Portland. I do believe that the good representative is here. And before the analysis, we should probably hear from the bill sponsor about the amendment.
I missed the bill number, Senator.
473, Senator Guerin.
Thank you.
Thank you.
Thank you, Senator Hickman. Good afternoon, committee. As you all know, this is a rental assistance and guarantee program. And I want you to know that in preparing for coming to you today, I've been working closely with Maine Housing and with landlords to really hear your concerns around and concerns of those brought at the committee hearing, particularly from landlords about not wanting to be tied to the guarantee program and wanting to have a state voucher program, to really get at that 25,000 person wait list for Section 8 vouchers, but not have to remove barriers if they don't want to. And I definitely heard that. And so what we've brought to you today in Maine Housing is here to explain it as well for folks who want them to, is that we've separated the programs out. And so there is a state voucher program for any landlord to participate in that Maine Housing would run, similar to other programs they run, and they would make the rules on how that program works. And then a separate program in this bill is the rental guarantee program. And that would be applicable to those landlords who participate in removing the application barriers to applying for housing. And then they would get the benefit of the $5,000 guarantee and the housing navigator programs. So we've separated them both out, and I really think it finds that right balance that was raised as concerns at the hearing.
Thank you, Representative. Mr. Langland, can you please put up on the screen the specifics of this amendment? And if Mr. Jorgensen is here from Maine Housing, he can turn on his video as well. Or is there someone else from Maine Housing? I'm sorry, it wouldn't be Jorgensen, but it would be on this issue. Is it Mr. Greeley? I'm still learning. who represents
Peter Marion.
Okay, thank you. All right. So, Mr. Langland, please walk us through the language.
So I'm probably not the best person to do this because I haven't been working as extensively as the sponsor has with Maine Housing. But my understanding is that, as she said, the program was sort of split into two parts. There is the rental assistance part, and there is also the housing navigator and guarantee part. The there was a reporting requirement that was added. So on a biennial basis, every 2 years, beginning in 2023, Maine Housing will have to report on the program to the committee with jurisdiction over housing matters, as well as providing a sort of a request for funds if necessary to provide rental assistance to a minimum of 1,000 households currently ineligible for or who are on the wait list for other rental assistance programs. The amendment also asks for a general fund appropriation of $9 million. And I would defer certainly to Maine Housing and to the sponsor, who are much more tuned into what's in the bill than I am. I did receive it yesterday and I sort of went over it and made it look pretty, for lack of a better word, and conforming with drafting standards, but certainly on the substance, I think they're probably the best people to ask.
That is great. Thank you, Mr. Lang. We may ask you to put that up again. I don't see, oh yes. Mr. Merrill, please step forward and turn on your video, please, and walk us through the amendment. Thank you.
Thank you, Mr. Chairman. Really, both Representative Morales and Mr. Langland have covered the gist of it. I'm happy to answer any questions or go into more detail, but only if that's necessary.
Thank you. Are there any questions from the committee at this time? Representative Drinkwater.
Thank you, Mr. Chair. If Mr. Langland could just scroll down a little bit, I was just trying to make some notes on the landlord cannot consider background. And my question had to do with that. Not consider the tenant's criminal record, credit score, and rental history, and to waive appropriate fees, and to not require the last month's rents in advance. So I guess if I'm a landlord and I need to consider my tenant's background for the safety of the single mom with 2 little children that is renting, the other apartment in my building. So what is a landlord to do?
Could I answer that, Drinkwater, or would you rather have Maine Housing answer that?
Oh, both is fine.
Okay. Is that all right, Senator?
Representative Morales, you may answer.
Thank you so much. So thank you for the question. And I think it goes to how we have separated out the 2 programs, Representative. So the way that this amendment reads is that any landlord can receive state funding through this voucher program without giving up the right to ask any questions on their application process, including criminal record check, including credit score, including the fees that they may have, first and last month's rent, any other application fees that go along. That is not a part of receiving the funding from the voucher program. What that section that you just referenced only applies to is if the landlord wants to participate in the guarantee program that has the benefit of coming with a housing navigator who acts as a liaison to the landlord, as a sort of property manager assistant, to check in with the tenant, to check in with the landlord, to make sure the relationship is strong. If the landlord wants to participate in that program, then they will remove the barriers to applying, and they'll have the benefit of a $5,000 guarantee of every tenancy if they participate in that program. So it's an incentive. And I think the message was at the hearing, that I heard, and we all know the adage, you can, bring a horse to water, but you can't force them to drink. And I think that's right. We have to work with incentives to bring folks on board. And so that's where the balance comes in. Did I explain that appropriately?
Thank you.
Mr. Merrill, do you want to add anything to that?
I would just underscore that it is completely voluntary. It is divorced from the first part, and that the concept is based on a program that Representative Morales operates in the Portland, South Portland area right now with some with success, and that's how this came to be, I believe.
Thank you. Representative Drinkwater, are you satisfied at least with the answer to your question? Do you need to see more of the screen? Representative Drinkwater, are you there?
I am. I just had a hard time finding the mute button. Thank you, Mr. Chair. I'm all set.
Great. Are there any other discussion points from the committee? If the committee members could please turn on their cameras, that's one of the challenges of this particular approach, is that I can't see how many people are actually in the room, so that we make sure we maintain a quorum for the purposes of making motions and voting. So I only see 1, 2, 3, 4, 5, 6. Any other committee members willing to turn on their cameras?
I will say that in the moment that I believe Representative Gear and Representative Pebworth have their hands up.
I'm getting there. I just wanted to see who was here. Representative Gear.
Thank you,
Please.
Mr. Chair. In recognition of the dramatic challenge that we have in getting housing for people, and also in recognition of the work that Representative Morales has done in addressing the concerns that were raised around this bill, and I think it does a great job of giving an incentive to landlords to participate. And as we heard in the testimony that came before us, there are landlords eager to help in this situation, and they just need the correct program to do it. So I think this bill does that. And with that said, I move ought to pass as amended.
There's a motion on the floor. It's ought to pass as amended by Representative Gear. Is there a second? Seconded by Representative Warren. Representative Pebworth.
Thank you, Mr. Chair. I appreciate the motion on the floor and intend to support it. We've heard, to me, 2021, I feel like the word of the year is navigator, and that is such an important piece of this program. And I really also appreciate choice. And so having landlords have the ability to opt into this program makes a lot of sense to me. I really appreciate the sponsors' work on this and intend to support it.
Are there any other questions from the committee? Any other discussion points on the motion? Seeing none, now I need to see 7 people before I call the roll. So if Mr. Merrill, you would turn your video off, I appreciate it. Thank you very much. Representative Morales, the same. If you would please turn your video off, thank you very much. And I only see 5 faces. So we cannot take this vote until I see 7 faces at least from the committee. 1, 2, 3, 4,
I
5.
see 9, Mr. Chair.
I don't know what's wrong with my screen. Great. So the committee is ready for the question. Ms. Thompson, please call the roll.
Senator Hickman.
Yay.
Hickman, yay. Senator Guerin.
No.
Guerin, no. Senator Miramont.
Yay.
Miramont, yay. Representative Sylvester.
Yay.
Sylvester, yay. Representative Bradstreet is absent. Representative Cuddy. Cuddy is absent. Representative Drinkwater.
Nay.
Drinkwater, nay. Representative Gear.
Yes.
Gear, yes. Representative Morris.
No.
Morris, no. Representative Pebworth.
Yes.
Pebworth, yes. Representative Prescott is absent. Representative Rader.
Yes.
Rader, yes. And Representative Warren.
Yes.
Warren, yes. That is 7-3 with 3 absent.
7 voting in favor of the motion, 3 opposed with 3 absent. The motion prevails. What is the minority report?
Ought not to
Not to
pass.
pass.
Ought not to pass it is. I will close the work session on LD 473. I've discovered the problem with my screen. I had to move it back to page 1. Senator Miramont?
Thank you, Mr. Chair. At some point, I realized that I was on a bill of mine in another committee that I missed the vote on 1489. If you'd allow me to vote now or sometime today, please.
You can call that in to the presiding officer since we've already closed the vote. Thank you.
Okay.
I will open the work session on LD 553, an act to end at-will employment presented by Representative Mike Sylvester of Portland. Mr. Langley?
So we already had a work session on this bill, and it was tabled at the last work session pending additional work by the sponsor, our own Representative Sylvester. I don't know if he has any more that he'd like to add or any potential amendment he'd like to introduce.
Chairman Sylvester.
Yes, thank you, Mr. Chair. Yes, Mr. Langland, if you could show the committee the amendment that we worked up. and I'll briefly explain it, and then have you go through it substantively. What we were trying to capture were some of the commentary from employers. I had a lot of discussion offline, as I had said at the first work session, with folks who were worried about situations, the myriad of situations in which an employee might have some act that the employer deemed no longer allowed them to be an employee, or to safely or be on the premises, and the inability to list all of those. And so those were the two issues that I tried to address in this amendment. The first being that employers could list a series of acts in their handbook that were fireable offenses that would be particular to those workplaces, realizing that every workplace is different. One workplace, it might be handling chemicals. In another, it might be some other situation with customers. And so that allows employers in their handbook to list and make known to employees the list of offenses that would be fireable offenses that might be different from other workplaces, and that would certainly be different than violating a state law. The second thing was to give a latitude to employers to deem something that they might not have been able to foresee as a fireable offense, and to move the progressive discipline into the stage of termination. And so that is what this amendment does. But Mr. Langland, if you could walk us through the language.
So as Representative Sylvester said, the bill as originally drafted allowed an employer to terminate an employee immediately, only if they had violated any state law. So the amendment that I drafted for Representative Sylvester allows an employer to proceed with termination based on additional criteria, including the highlighted section on the screen. So if in the judgment of the employee has committed an action that either endangers the safety or well-being of the employer, the employees or customers, or hinders the ability to operate the business under normal operating conditions, or may harm the reputation of the business in the community. And as Representative Sylvester just referenced, there is also a provision added that if an employer has in its employee handbook offenses listed that are deemed fireable, then if in the judgment of the employer, one of those has been violated by an employee, then the employer can proceed directly to termination without going through the progressive disciplinary process.
Thank you, Mr. Langland. Chairman Sylvester.
Thank you. I just wanted to make a few more statements about this bill, because I think that we've focused a lot on at will because it's in the title, and justly so. You know, we talk a lot about other states and whether or not they've done things, but I think a couple things need to be noted. That the United States is unique in industrialized countries of even having this concept of at-will employment, of even having the concept of letting an employee go for no reason. There is no other industrialized country that does that. But I think that also when we're talking about, as we have been in this country over the last year, as we're talking about trying to break down systems of oppression and systems that unfairly marginalized people who have been marginalized throughout the history of this country, and perhaps is one of the reasons we have this concept, is the fact that people who have lower amounts of resources are the ones who are most affected by at will. So people who are on the poorest and lowest rungs tend to be the folks who will not report violations, who will not report harassment, who will not employ, who from the fear of being fired for any reason or any act or no act at all will tend to put up with unfair working conditions. And this is particularly true of Black and Latinx communities in this country. And so, so I think it's important to say that. But the second part of this bill is about just cause, is about having a clear handbook that sets out the rules, about having a procedure so that everyone gets to have their day to explain situations and aren't just fired at will. And just cause and having just cause rule is a very popular concept in this country. A 2021 study showed that 71% of Americans are for just cause provisions. 67% of Republicans are for just cause provision, although I will grant probably not 67% of this committee, but 67% of the Republicans that were asked in these polls. And I think that that's important because I believe that, having said everything else, that Americans believe in fairness and that we believe in systems that give people that fairness. And that is what this bill is trying to achieve. And so with that, I would ask the committee to support this, and when you're ready to take a motion, sir.
Thank you, Chairman Sylvester. Mr. Langland, you may please stop sharing the screen. I think that people have seen, I wanted it up for as long as people could see the proposed provisions in the amendment. Representative Drinkwater.
Thank you, Mr. Chair. I won't take as long as my good friend from Portland did. 200 years, we're just celebrating a bicentennial. And this bill wants to undo 200 years of at-will employment. I agree with the concept that you just can't fire somebody because they have a mustache. I just can't support forcing every employer in this state that is non-union to have these rules. So I will not be voting for the motion.
Representative Drinkwater, if I may ask you a question, if you support not firing someone because they have a mustache, then do you have any other way that that could happen except for this bill?
You mean to fire somebody?
You said you do not support an employer fire someone just because they have a mustache.
That's correct. I do not, I would not, and I would not work for that person either.
But they have a right to do that right now because there is no law to stop that.
The employee also has a right to go to the Maine Human Rights Commission and file a complaint for discrimination because they have a mustache. There are avenues of ways to help the employee.
Not to be argumentative, but having a mustache is not a protected class in the state or in
correct.
So they could be fired for not having a mustache and there would be no recourse.
Well, yeah, whatever.
Senator Miramont.
Thank you, Mr. Chair. I have, on the campaign trail in the community, heard so many times from folks how they cannot get rid of an employee. I heard it so much that I stopped believing that there was still at-will employment. And I was surprised when this bill came. But to match it with all these other folks that tell me all the time that they have to go through a process of writing someone up at least a couple times until the third event, and the fact that they fixed the ones about the most egregious incidents that really do need people to be off the job immediately, I move this ought to pass as amended.
Been moved ought to pass as amended by Senator Miramont. Is there a second? It's been seconded by Representative Geer. Representative Rader.
Thank you so much, Mr. Chair. To the point about the Maine Human Rights Commission, I know that they're already dealing with a massive amount of cases that have been brought forward to them. I have a friend who was told that the average wait time is several months. So one of the reasons that I intend to support this bill is so that we can keep some of those cases away from the Maine Human Rights Commission so they can focus on their work. And yeah, that's why we'll be voting not to pass as amended. Thank you.
Senator Karen.
Thank you, Mr. Chair. I've just been looking through some of the testimony that came before our committee, and overwhelmingly, the business community is opposed to this legislation for the rights of businesses and their employees to be able to have a workplace that is agreeable to all. Just to quote the Maine State Chamber, the Maine State Chamber of Commerce stands in strong opposition to the passage of LD 553 in any form. It will harm both businesses and their employees. We urge the committee to give this bill a unanimous ought not to pass recommendation. That's from the state's largest business group. And as you all will remember, there were numerous businesses and business groups in testifying in opposition to this bill, and I will be voting ought not to pass.
Thank you, Senator Guerin. Are there any other comments about this bill from the committee? You know, I will say that I'm an employer and I have been an employee, and I've obviously only worked in at-will employment states. And I used to be a waiter. And one day, out of the blue, for no reason that I knew, I was fired. I was told not to come to work. And then when I found out why I was told not to come to work, I was fired. So I had to ask my employer why I had been fired when I had had no problems with the customers, always went to work on time, always made really good tips because I was a very good waiter. And she looked at me and she said, I don't like you anymore, and I can't stand that you wear all of those rings. And so you no longer have a job here. I have the same rings on right now, just these 3. And I was fired, and there was no recourse. I could not collect unemployment. I could not file a discrimination complaint because she didn't fire me for any other reason, in her words, except for she didn't like me anymore and she didn't like my rings. I don't know if that's fair to any employee to have to deal with that. And so while I understand the concerns of the business community, I do believe that Chairman Sylvester in good faith has addressed some of those concerns. And we had members of this committee, myself included, who were not sure that I could support the bill as written. And all of the testimony came in was on the bill as written. And for me, this more than modest attempt to be fair to employers while making sure that workers have their rights protected on the job is enough for me to vote yay. Representative Geer.
Thank you, Mr. Chair. And I seconded the motion, and I do intend to support this vote. As an employer, I have experienced a number of different scenarios where it wasn't possible to keep an employee around for a day longer. And I did have detailed discussions with Representative Sylvester on these, really, and I had a very substantive discussion to acknowledge that there are those situations. I think he did a great job of making sure that those were covered in the bill. And I do think this bill gives employers the correct incentives to create a clear employee handbook that sets expectations for employees, to have a progressive discipline process in place to make sure that there is an order to the process of educating an employee how to be a better employee. And there is recognition that there are times when all of that just can't work and someone needs to be moved on. And so I think the bill addresses a core issue in our system, and it does it with the appropriate balance between the needs of employers and employees. And for those reasons, I will be supporting this motion.
Representative Morris.
Thank you, Mr. Chair. Does this bill make it clear that I have real concerns? I will not be supporting the motion, but I have real concerns too with the seasonal, with the number of seasonal employees with our retail association and so forth. I'm not sure that it makes it clear that they could be laid off at the end of the season. And that's certainly a concern too, because a number of businesses hire people just seasonally.
Chairman Sylvester.
Thank you for the question, Representative Morris. So layoff is a very distinct legal term in labor law. It is different than termination. So any sort of layoff that happens either because of reduction of force or because of seasonal issues, right? I run a seasonal business. When we close, employment is over. Those folks are laid off. And so that would not be covered by this bill. And so it's merely discipline for an action. the employer closing is not an action that is disciplined upon the employee, and so it would not come into play in this bill.
Any other discussion on the motion from the committee? The motion is ought to pass as amended. Is the committee ready for the question? The committee clerk will call the roll.
Senator Hickman.
Yay.
Hickman, yay. Senator Guerin.
No.
Guerin, no. Senator Miramont.
Yay.
Miramont, yay. Representative Sylvester.
Yay.
Sylvester, yay. Representative Bradstreet is absent. Representative Cuddy is absent. Representative Drinkwater.
Nay.
Drinkwater, nay. Representative Gear.
Yes.
Gear, yes. Representative Morris.
No.
Morris, no. Representative Pebworth.
Yes.
Pebworth, yes. Representative Prescott is absent. Representative Rader.
Yes.
Rader, yes. And Representative Warren.
Yes.
Warren, yes. That is 7-3 with 3 absent.
7 members voting in favor of the motion, 3 opposed with 3 absent. The motion prevails. The minority report.
Ought not to pass.
Ought not to pass it is. Thank you. I will close the work session on LD 553. I will open the work session on LD 959, an act to protect small businesses by ensuring that a prevailing wage is paid on public works construction projects, presented by Senator Dave Miramont of Knox. And Mr. Langland, please defer. Senator Miramont.
Thank you, Mr. Chair. Yes, we have another bill to work with this. I don't think we need 2. I'd like to put the effort into that, and I'll move this ought not to pass.
Been moved ought not to pass by the bill sponsor. Is there a second? It's been seconded by Representative Warren. Any discussion on the motion? Seeing none, Ms. Thompson, whenever you are ready, please call the roll.
Senator Hickman.
Yay.
Hickman, yay. Senator Guerin.
Yay.
Guerin, yay. Senator Miramont.
Yay.
Miramont, yay. Representative Sylvester.
Yay.
Sylvester, yay. Representative Bradstreet is absent. Representative Cuddy is absent. Representative Drinkwater.
Yay.
Drinkwater, yay. Representative Gear.
Yay.
Gear, yay. Representative Morris.
Yes.
Morris, yes. Representative Pebworth.
Yes.
Pebworth, yes. Representative Prescott is absent. Representative Rader.
Yes.
Rader, yes. And Representative Warren.
Yes.
Warren, yes. That is unanimous of those present.
The unanimous vote of those present, the motion prevails. I will close the work session on LD 959 and open the work session on LD 1312, an act to remove excuse me, we're not taking that bill up today. And I forgot to announce that from the beginning. I apologize for anyone waiting on that bill. We will take it up on Monday when the bill sponsor can be present. So I will open the work session on LD 1397, an act directing the Maine State Housing Authority to create a commission to develop a comprehensive rental registry for multifamily housing, presented by Representative Tracy Gear of Kennebunkport. And I do believe we've already had a work session on this. So I will ask Mr. Langland to defer to the bill sponsor, Representative Gear.
Thank you, Mr. Chair. And I would ask Mr. Langland if he could to put up the amendment. We have a strike and replace amendment for this bill. And we can review that and go from there. I might be catching Mr. Langland off guard. I'm sorry, Steve.
No, that's okay. I'm just trying to open the document on my computer and. Oh, okay. Here we go. Okay. Are you seeing my screen now?
Yes.
Okay, perfect.
Do you want to review it, or can you want to walk it through?
I can try. So after discussing with the sponsor, I think the sponsor worked with Maine Housing. The sponsor wanted to strike the bill as drafted and replace it with a resolve. directing Maine State Housing Authority to work with the city of Lewiston, which is already has a rental registry program that's sort of up and running, but needs a bit of a boost. I believe the intent behind it, and the sponsor can correct me if I'm mischaracterizing it, is to come up with sort of a pilot project or a model that other housing authorities in the state can use. And there would be some reporting back to the committee on that process and any recommendations that Maine Housing and the city of Lewiston come up with in terms of crafting a model for how housing authorities can establish their own rental registry databases. I'm not sure how I did with that, but certainly Representative Geer can correct me.
Thank you, Mr. Langen. Appreciate it. Yeah, and I think the only thing that we just corrected in the latest version of this is that it is the city of Lewiston as opposed to the Lewiston Housing Authority that is the partner in this, and it is taking a rental registry database that is in a very early prototype version, and it would have the city of Lewiston and the team that's been working on this working with the with Maine State Housing with some supportive resources to move it to the next phase, where it could be actually out there and starting to have some use so that we can see how it could work with the rest of the state. Thank you, Steve.
Thank you, Representative Geer. Are there any questions from the committee? You can leave the resolve up just a few more minutes and I'll see if there are any hands raised. I'll say, with that, I will invite Mr. Jorgensen from Maine State Housing to turn on his video, introduce himself, and speak briefly about this resolve, the compromise that you have worked out with the bill sponsor.
Thank you very much, Mr. Hickman, Senator Hickman, and thank you, Representative Geer. And I also want to thank Steve for his hard work on this. As you may recall from our initial appearance before your committee, we were concerned about just how to do this on a statewide basis. I mean, not questioning the value of the idea, but it was just looking like a massive, monstrous, monumental, mammoth project. And we decided that I think when Representative Geer came to me and suggested that maybe we could transform this into a demonstration project with the Lewiston Housing Authority, seemed like a really good idea to me. They're game to go on this. We're eager to help them out as we can, and I think it's worked out really pretty well with this. What we see here. The one issue that I think that I still have a complaint, not a complaint about, still have a concern about, is the issue of, I'm just worried that by January 15th, 2022, we may not have all the information we need to provide a good, to provide a really comprehensive report on where this has gone. However, I recognize too that time is necessary for your coming up with a bill if you wanted to do more legislation around it. So that's not a huge issue for us. There may be a richer report to happen later, but we certainly could do something by January 15th, and I'm happy to do that.
Thank you, Mr. Jorgensen. So I'll just ask directly if you think there should be a different date there.
I think it would be great if it were maybe a little later, but I don't know where that came from. And, if it were to maybe go to, say, April 15th, that might be more, we might have more to report by then, but either way.
Thank you for that input. Representative Geer, do you have a response to that suggestion?
Thank you, Mr. Chair. This is where the goal, certainly in the way the bill was structured, was to make sure that we would have time to do a committee bill. So I don't know if there is time, if it's April 15th, but if so, that's fine with me.
No, that's probably right. I don't think there will be time. So we can stick with the January 15th. We'll certainly have ideas about directions by then, and that's fine.
Thank you.
Sounds good, Mr. Langland. You can please stop sharing your screen. Thank you. Okay. Senator Mearmont.
I'd like to move this ought to pass as amended, please.
It's been moved ought to pass as amended by Senator Mearmont. Is there a second? Seconded by Representative Rader. Motion is ought to pass as amended with the amendment presented by Representative Gear, along with Hope from Maine Housing. Is there any discussion on the motion? Seeing no hands, the committee is ready for the question. The motion is ought to pass as amended on LD 1397. Ms. Thompson, please call the roll.
Senator Hickman.
Yay.
Hickman, yay. Senator Guerin.
No.
Guerin, no. Senator Miramont.
Yay.
Miramont, yay. Representative Sylvester.
Yay.
Sylvester, yay. Representative Bradstreet is absent. Representative Cuddy.
Yes.
Cuddy, yes. Representative Drinkwater.
Nay.
Drinkwater, nay. Representative Gear.
Yes.
Gear, yes. Representative Morris.
No.
Morris, no. Representative Pebworth.
Yes.
Pebworth, yes. Representative Prescott is absent. Representative Rader.
Yes.
Rader, yes. And Representative Warren.
Yes.
Warren, yes. That is 8-3 with 2 absent.
8 members voting in favor of the motion, 3 opposed with 2 absent. The motion prevails. The minority report, please.
Ought not to pass.
Ought not to pass it is. Thank you very much. I will close the work session on LD 1397. I will now open the work session on LD 1436, an act to protect certain essential workers from infectious disease, presented by Representative Kevin O'Connell of Brewer. Mr. Langland, please present the bill analysis.
So this bill requires public and private employers that employ persons who provide direct in-person services in medical settings or in correctional institutions, or that employ firefighters or emergency medical services persons, collectively referred to in this bill as covered employees, to take certain actions with respect to providing personal protective equipment for those covered employees. The bill requires employers to supply personal protective equipment to covered employees and to ensure these employees use the personal protective equipment in accordance with occupational and safety rules of the Department of Labor. It also requires employers to maintain a stockpile of the following specific personal protective equipment equal to 3 months of normal use by covered employees: N95 filtering face piece respirators, powered air purifying respirators with high efficiency particulate air filters, elastomeric air purifying respirators and appropriate particulate filters or cartridges, surgical masks, isolation gowns, eye protection, and shoe coverings. If an employer's covered employees work in a facility or other setting controlled by another employer that must stockpile equipment for its own covered employees, the employer that controls that facility or other setting is responsible for meeting the stockpiling requirements for all covered employees who work in that facility or setting. The bill provides that on or before January 15th of next year, an employer is required to determine its highest 7-day consecutive daily average consumption of personal protective equipment and to provide this information to the DOL upon request. The bill provides for civil and administrative penalties for violations of the requirements of the bill. There was a lot of discussion that factors beyond an employer's control can prevent employers from having adequate stockpile, such as high demand, a lack of supply. There is a provision in the bill that discusses factors beyond the employer's control. So it's possible that if this bill were to move forward, the committee might want to consider adding language specifying that a shortage of a global supply is a factor beyond an employer's control. The committee also heard discussion that the bill as drafted requires employers to keep 3 months stockpile, and that upon use of the stockpile, the threshold drops below the 3-month supply, which could create a potential violation subject to penalty by the Department of Labor. I think the committee could add language to clarify that the intent is not to punish employers for tapping into the supply, but to ensure that during the next health emergency, the supply is there. The committee might want to consider adding language that specifically says that if the bill is to move forward. There was discussion that a resolve directing the Maine CDC or Maine Emergency Management Agency to keep a centralized stockpile of PPE is more effective alternative to this proposal. There was also discussion at the public hearing that perhaps one or more regional locations that contain PPE is more effective. The Department of Labor does not have enforcement authority over private employers and federal government employers in the state of Maine, as we know. That falls to federal OSHA. the Department of Labor does have enforcement authority over state and municipal government only. So OSHA at the federal level might propose regulations in this area in the near future, in which case Maine's Board of Occupational Safety and Health will need to adopt rules. The committee made a couple of requests for information, one of which was to have representatives from the Maine CDC and MEMA to weigh in on this proposal generally, as well as the potential resolve directing them to keep the stockpile instead. And I understand that John Hernandez and Bill Jenkins from the CDC are here. If you wanted to direct specific questions at them and gauge their thoughts on what those proposals might be, as well as Joe Legge from the Maine Emergency Management Agency. There was also a committee request for the section of requirements of participation that outlined what emergency preparedness plan looks like and what was added by the federal government on lessons learned. The committee heard testimony that that was just released by the federal government and updated on April 16th. I have not seen that. So if that has come through from a committee member, feel free to share that. We have not yet received a preliminary fiscal impact statement on the bill. And that is the extent of my analysis. I'm happy to try to answer any questions. And as I did say, there are some representatives from the CDC if the committee wants to gauge their interest in the alternatives that were discussed at the public hearing.
Thank you, Mr. Langland. Chairman Sylvester.
Thank you, Mr. Chair. I do want to call them forward. I want to call them forward on a specific idea. I think that, you know, as the Committee of Jurisdiction on Worker Safety, I think everyone on the committee wants to make sure that people have the proper PPE. In looking at this bill, there seem to be a lot of, I guess, more questions than answers within the bill in terms of how this would solve an ongoing problem rather than the problem we just had. And so what we are proposing is to have MEMA work with the CDC to develop a plan to have proper PPE and recommendations for employers on the proper levels of PPE that might be necessary to have in different situations. For example, very different in, say, a retail situation than a hospital situation. And so my questions to both, and I think maybe starting with MEMA, is to ask what is already being done. Are we still just too deep in the crisis to have started to put together that ongoing plan? Is that something that you'd be capable of doing? And I'll leave it at that for right now.
Thank you, Chairman Sylvester. Who is here from MEMA? I do not. There goes my screen again.
It was Joe Legge.
Yeah.
Mm-hmm.
Thank you. Please introduce yourself, sir.
Hi, good afternoon, everyone, and thank you for having me. My name is Joe Legge. I'm the Deputy Director for Maine Emergency Management Agency. From what I just heard, it sounds like there's some discussion about kind of planning related to the availability of PPE, not just in response to the pandemic that we are in, but in kind of moving forward. I can provide maybe some general context on emergency planning and preparedness from a broad perspective, and then I would defer to Mr. Hernandez and Mr. Jenkins, who are also on here, very close partners of ours at the Maine Center for Disease Control, as really the experts in healthcare related preparedness and personal protective equipment.
Mr. Legge, I think that would be great. I think I'm also very interested in what the current planning process is going forward, and that's where I said, are we just too deep in the weeds to have begun to do that forward thinking? We're dealing with the moment, and because that's what I think what the amendment that's coming forward is going to ask you to do. So, any thoughts on that?
Sure. So there is, I think a common sentiment within emergency management and preparedness is that you start kind of planning and doing after action as soon as you start acting. As soon as the response starts, you start planning for those things. So I think that there are already lessons learned being collected by Maine Emergency Management, by CDC, by really all of the different partners that are engaged in the effort, certainly FEMA and other federal partners as well. I don't know specifically what those are as they relate to PPE. Our role has been mostly one of facilitating the request process for personal protective equipment during this. So we certainly have lessons learned from that perspective kind of what the need has been in the field, what the process has been to request it, and then the process to get it from the CDC to the end user. And we will certainly be conducting a very comprehensive after action report and improvement plan following the kind of closure of the pandemic, so to speak. And we've been collecting some of that data thus far in the process.
Thank you, Mr. Legee. I will now ask for Mr. Hernandez and or Mr. Jenkins to weigh in on the same question that, oh, I see that Representative Gear has a question before I move on. Sorry about that, Representative.
No, I'll defer and wait to hear from the other folks.
Perfect. Mr. Hernandez, please introduce yourself.
Yes, good afternoon, everybody. My name is John Hernandez. I am the Medical Countermeasures Manager for the Maine CDC Public Health Emergency Preparedness Program. My roles and responsibility here are basically logistical aspects of the warehouse operations we are currently doing right now in regards to the COVID-19 response. Some issues and concerns that we have with this suggestion of the Maine CDC or MEMA housing or storing this PPE for every entity that performs healthcare treatment in the state of Maine is really unrealistic. Right now, we are using several warehouses, close to 1 million square feet of square footage for the storage of the personal protective equipment we got right now, and it's not enough to cover every entity in the state of Maine. Also looking at this, we've spent over $30 million with federal grant money to build up our stockpile for this COVID-19 response and to future incidences, if I could say. Currently right now, we've been working on our focus group is the percentage of PPE that we're going to keep in reserve for the future if something was to happen off of what we have currently right now. And we call that the gold standard. That gold standard is several 100,000 pieces of equipment that you had mentioned in your list, minus a few, some of the more expensive items that are we'll probably procure later. So with that being said, we have a idea of what we want to do in the future with 30%, and that we're trying to get into scale down into our warehouse that we have currently right now. So we're trying to right now we're trying to deplete what we have on hand because, like I said, we've got several locations, several warehouses with the product that we have, trying to bring it down to size for us to manage. Like I said, the state of Maine and MEMA could not house the PPE for every agency in the state or the healthcare facilities just because of the size and magnitude of it. Another thing we look at is the shelf life on this PPE. This product, like I said, we spent over $30 million on the PPE we purchased. It's got a shelf life of 5 to 10 years at most. So we recommend that the treatment facilities and these healthcare facilities manage their own inventory because they can rotate that stock into their daily uses and rebuild up that 30% cash, whereas our 3 months of supply where we could not, we would be sitting on that for years. And then we'd be here later on explaining how we lost millions of dollars of PPE or product because it expired. And that's what I've got. Bill, do you have anything you would like to add?
Thank you, Mr. Hernandez. If Mr. Jenkins could turn on his camera, introduce himself.
Good afternoon, folks. Good afternoon, Senator Hickman. My name is Bill Jenkins. I am the current director for the Public Health Emergency Preparedness Program at Maine CDC. And thank you to Director Legee for kind of tipping us off that this was coming through the Labor and Housing Committee. The federal government already has numerous requirements for healthcare sectors to have personal protective equipment. It's not specifically spelled out as personal protective equipment. It's under the life and safety codes. So if you're a hospital, Joint Commission does require hospitals to provide equipment and supplies to adequately protect their employees as well as patients and visitors. If you're a long-term care facility, a home health or a hospice facility, CMS implemented the emergency preparedness rules a few years ago, which have similar requirements. So, what we've seen, the reason that we have been in this position is because healthcare organizations work on profits, right? If you were to ask anybody and say, hey, I want you to spend 3 months worth on PPE, they're going to say absolutely not. Our margins are way too small. we can't do that. So kind of what got us into this mix is that the healthcare providers, aren't prepared to take care of their own. So we at the state, our grant program here is to help provide gaps. We're kind of a last resort. So our expectation is that, a local health care facility would have enough equipment and supplies on hand per their CMS and JCO regulations to be self-sufficient for 96 hours. That gives us at the state some time, whether it's FEMA, MEMA, CDC, time to kind of deploy, figure out what these healthcare systems may need. But again, that comes out of my operational budget. So I don't feel like, we should be spending our operations budget to purchase PPE on behalf of a private sector healthcare system. So, there's a lot of things at play here. Like John had mentioned, our role is to basically make sure that if a emergency at a local level, the healthcare system doesn't have the resources, we do have emergency supplies and equipment on a state level that we can deploy. But I don't think I can condone really shifting the responsibility from the healthcare system onto the state to kind of manage and inventory that. There's a lot of intensive resources that go into medical logistics. And frankly, a lot of the large healthcare systems already have very large warehousing facilities and logistical processes in place to ensure their affiliated healthcare systems or facilities have these types of things. So I guess from our perspective, I think we would be, from the CDC's perspective, certainly be willing to help plan. I don't think I would be saying yes. I think, the state of Maine, MEMA, CDC should be in the warehousing business for private sector healthcare systems.
Thank you, Mr. Jenkins. Representative Gear, did you have a question for any or all of the above?
Thank you, Mr. Chair. And Mr. Jenkins, I think you're hitting on just a really, really key vulnerability in our healthcare system, given the balance that we have between private, hospitals and healthcare institutions and the government. I know we take, for example, the banking industry, right? The banking industry requires that banks maintain, the government requires that banks maintain a certain level of cash reserves to be available in an emergency. And they stress test those banks to make sure that they can respond in a real and timely fashion if there's a financial crisis. I'm wondering if you think the same thing should be in place given the experience that we've had with COVID in the healthcare system, where there would be some clearer, it sounds like maybe clearer connections between the need and then what materials are being deployed where.
Certainly, thank you, Representative Gear. So one of the programs that I administer here at the CDC is the Hospital Preparedness Program. So through that, we're charged with forming healthcare coalitions. Now, these are coalitions that are comprised of folks from many, many different healthcare organizations. We provide funding to healthcare coalition directors to bring all of these disparate folks in and say, okay, we're going to help you folks develop all hazards emergency operations plan. We also do a lot of exercise and training of said plans. We can help facilitate that. And we also do a lot of things around hazard vulnerability analysis. So we take a look at, where are the gaps in the healthcare system's preparedness, as well as the state CDC and MEMA. And then we try to focus our resources on making sure we can fill some of those gaps. One of those is also obviously supply chain integrity. One of the things that we all kind of, saw or are currently seeing is that, domestic production of a lot of our PPE is made overseas. So, again, that's neither here nor there for this committee, but those types of things should all be part of that. And, we take a look at that, and supply chain is a big vulnerability for us. And it's even more so after we've kind of come out, hopefully on the tail end of this pandemic, to say the only folks who really had any PPE were the state health departments. And again, that was only because we received federal grants from LBHS to say the state has to be in a position to be able to respond to a health emergency. So, yeah.
Thank you.
I would wholly agree. And again, some of their CMS and Joint Commissioner requirements do require exercises and training of those very plans.
Thank you. Chairman Sylvester.
Thank you. I really appreciate all of you coming forward today. It sounds like we were, scratching at the right itch here in terms of what might be needed in looking at planning and making sure that we're learning the right lessons. So from what I'm hearing, you would be amenable to, being able to put together a report of some kind to this committee of sort of what went right, what went wrong, recommendations about what might be done better, or for example, specifically, do we need to be more specific about what PPE we're talking about, those sorts of things, if they're going to keep a supply that the federal government asks them. And then, and then maybe being able to look at that data and see if some action needs to be taken. And I wouldn't want to, I see you nodding your head, Mr. Jenkins. I wouldn't want to take that action without you being able to work on the amendment with us. And so with that, I would make a motion, Mr. Chair, that we table this bill for today. I believe it's 1436, to be able to work on an amendment to do that.
So I will say that the committee should certainly consider working with the gentleman in front of us on any amendment. And so you made an argument for the motion, which is not debatable. I will entertain a motion from the committee to table the bill. Representative Cuddy. Are you making the motion to table?
I am, so moved. I couldn't get to my mute button, but so moved.
It's been moved by Representative Cuddy. It's been seconded by Senator Miramont. Would you all please turn on your videos, and we will take the vote by a show of hands. All in favor of tabling LD 1436, the motion to table. All those in favor, please indicate with a show of hands. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. All opposed? 1 opposed. The motion prevails. The bill will be tabled. And we will take this up next week, Monday or Wednesday or Friday, whenever we are ready with language. That said, I will close the work session on LB 1436, and I will ask Senator Guerin, if you, regarding LD 1453, I know that Representative Bradstreet isn't here today, and I had not heard from him, so I didn't know if you wanted us.
I will send a message for him if I may, Mr. Chair.
You may.
He said to thank you for your consideration of his bill and for us to go ahead and vote on it today, even in his absence.
Thank you very much for that. So I will open the work session on LG 1453, an act to protect small employers by prohibiting municipalities from adopting ordinances regarding employee work benefits other than ordinances regarding minimum wage rates, presented by Representative Bradstreet of Vassalboro. Mr. Langland.
So this bill prohibits municipalities from enacting or enforcing an ordinance, regulation, or order regulating wages or benefits of an employee provided by an employer, except for an ordinance concerning a life safety matter or establishing a minimum wage rate for a particular class of workers during a particular period of time. The committee heard in its testimony at the public hearing that a patchwork of ordinances from place to place creates a difficult business environment. Municipalities are exceeding the scope of home rule by enacting wage ordinances and the consideration of paid leave laws. Local labor ordinances disproportionately impact small businesses, which can easily buffer the cost of such an ordinance. There was testimony at the public hearing that home rule doesn't envision municipalities acting as legislative bodies on labor matters that are not preempted by federal or state law. The committee also heard testimony that residents should retain the authority to weigh the benefits and threats and make decisions on a variety of issues that address the community's interests and priorities. And there was testimony at the public hearing that the legislature's ability to limit local authority should be used sparingly. The committee has not yet received a preliminary fiscal impact statement on LD 1453.
Thank you, Mr. Langland. Senator Miramont.
Yes, I'd like to move this ought not to pass, please.
Senator Miramont has moved LD 1453 ought not to pass. Is there a second? Seconded by Representative Rader. Is there any discussion on the motion from the committee? Seeing none, the committee is ready for the question. Ms. Thompson, please call the roll.
Senator Hickman.
Yay.
Hickman. Hickman, yay. Senator Guerin.
Yes.
Guerin, yes. Senator Miramont.
Yes.
Miramont, yes. Representative Sylvester.
Yes.
Sylvester, yes. Representative Bradstreet is absent. Representative Cuddy.
Yes.
Cuddy, yes. Representative Drinkwater.
I'm sorry, but the motion was ought not to pass.
Yes, sir.
Nay.
Drinkwater, nay. Representative Gear.
Yes.
Gear, yes. Representative Morris.
No.
Morris, no. Representative Pebworth.
Yes.
Pebworth, yes. Representative Prescott is absent. Representative Rader.
Yes.
Rader, yes. And Representative Warren.
Yes.
Warren, yes. That is 9-2 with 2 absent.
9 members voting in favor of the motion, 2 opposed with 2 absent. The motion prevails. What is the minority report?
Ought to pass.
Ought to pass it is. I will close the work session on LD 1453. That concludes everything on our list today. Now, Mr. Langland, did we vote LD 10002 on Wednesday at the end, or did we forget to do that?
Forgot to do that. Yeah.
Okay. Thanks for that catch. I think we're just so excited to be done. We left. So with that, I will entertain a motion to go into work session on LD 10002, which the bill sponsor requested we dispense with on the day. We just forgot to do it at the end. Senator Miramont.
So moved.
Been moved. Is there a second to go into work session on LD 10002? It's been seconded by Representative Rader. Please turn on your videos. Show of hands, all in favor of the motion to move into work session on LD 10002. It is unanimous. And for those who were not here on Wednesday in the attendee list, Representative Allison Hepler asked us to kill her bill. Senator, Mr. Langland, can you please give us the bill title since I don't have it in front of me at the moment?
Sure. Just give me a second. I need to plug it in. I don't have it in front of me either, but.
I will take a moment to do this efficiently and correctly.
So LD 1002 is an act regarding the availability of health insurance coverage for dependents of certain state employees.
I will open the work session on LD 1002 by that title. And I will entertain a motion about not to pass. Chairman Sylvester.
I would move out not to pass.
Been moved by Chairman Sylvester, seconded by Representative Cuddy. Ms. Thompson, whenever you get your paperwork ready, please call the roll.
Senator Hickman.
Yay.
Hickman, yay. Senator Guerin.
Yay.
Guerin, yay. Senator Miramont.
Yay.
Miramont, yay. Representative Sylvester.
Yay.
Sylvester, yay. Representative Bradstreet is absent. Representative Cuddy.
Yes.
Cuddy, yes. Representative Drinkwater.
Yay.
Drinkwater, yay. Representative Gear.
Yes.
Gear, yes. Representative Morris.
Yes.
Morris, yes. Representative Pebworth.
Yes.
Pebworth, yes. Representative Prescott is absent. Representative Rader.
Yes.
Rader, yes. And Representative Warren.
Yes.
Warren, yes. That is unanimous of those present.
It is unanimous of those present. The motion prevails. LD 1002 will be in the dustbin of history. I will close the work session on that. Just for anybody that is here, we were not taking up LD 1312 today because the bill sponsor would like to be present, and we'll schedule that on Monday. With that, we are finished with all of our work scheduled for the day and what we forgot about from Wednesday. Mr. Langland, do we have any language reviews?
We do. We actually have a ton if you're interested in sticking around for a while.
It's o'clock. We've got to work until 5, don't we?
So I have a variety. I could start with the divestment bills, if that's preferable for the committee.
Where you'd like to go in is fine with us. So I'll let you call that.
So I will start with LD 99, and I'm going to share my screen actually.
Thank you.
So this was Representative O'Neill's bill, which was an act to require the state to divest itself of assets invested in the fossil fuel industry. You should have received in your emails a memo from the Maine State Retirement System, or well, Maine PERS now, with their concerns about some of the particular language, which I've highlighted here. And I have not shared this with anyone at this time, so I certainly would need some feedback from Maine PERS if I captured what their concerns were. I understand the sponsor has agreed to this change. So this change here further defines a fossil fuel company. So initially it said a fossil fuel company means any company that owns any fossil fuel infrastructure, but Maine PERS recommended, and my understanding is the sponsor also agrees, as well as the State Treasurer's Office, that it be changed to has as its core business the construction or operation of fossil fuel infrastructure. There was also a discussion in Maine PERS memo to the committee about language on investment in fossil fuel companies. So typically what had happened for language in the bills in which Maine PERS had divested in the past was the language would read, the board, in accordance with sound investment criteria and consistent with fiduciary obligations, may not invest the assets of any state pension, etc. So my understanding is that the sponsor of the bill, Representative O'Neill, is also in agreement with Maine PERS on this language. And my understanding, and Maine PERS can certainly correct me if I'm wrong, because I understand that they're here, was that they recommended the sentence up after fossil fuel company, and then everything else after that in that sentence be struck. The other piece that Maine PERS recommended in its memorandum to the committee surrounded the environmental, social, and governance policy. So if you recall, the original language said that the report has to disclose environmental performance metrics, and it listed out what they are, which is the language that I'm showing here that's struck through. My understanding is that what Maine PERS recommends is to strike out everything that I have struck out, and at the end of subsection 5, include a sentence that says the report must disclose commonly available environmental performance metrics. I don't know how the sponsor, Representative O'Neill, feels on this issue. I was involved with some correspondence between the retirement system and the sponsor, but I don't know if Representative O'Neill has weighed in, and I don't know if she's here at this point in time. But that was my understanding of what Maine PERS recommended. Those were the only changes that the retirement system flagged in its memo, but one thing that I wanted to flag for the committee was that the report to the legislature actually, as originally drafted in the bill, says that it would actually go to the Appropriations and Financial Affairs Committee. And there are multiple reports that have to be submitted, sort of detailing the divestment process on January 1st in 2023, 24, and 25. And as well as a final one in 2026. So I don't know whether the committee would like to change that to the committee with jurisdiction over retirement matters, because as it stands now, it wouldn't come to this committee, but the committee currently has jurisdiction over retirement matters. As we've discussed sort of in the past in this committee, retirement issues were under the purview of the AFA committee at one point. And they've shifted back, sort of back and forth between AFA and labor. So I wanted to flag that for the committee. I don't know how the committee feels about all of the reports going to the AFA committee. So that was my thing that I wanted to flag for consideration. I believe that that was all of the issues that me and Maine PERS wanted to point out. So I hope that I didn't mischaracterize or misunderstand what they were saying. And as I said, I believe the sponsor feels the first two changes were okay, but I don't know how the sponsor feels about the third change that would be in subsection 5. With that, I'm happy to try to answer any questions, and go from there.
Thank you, Mr. Langland. Chairman Sylvester.
Thank you, Mr. Chair. As regarding the last thing, I would want it to go to the committee with jurisdiction over retirement issues, since that seems to make the most sense as it changes back and forth. I have been in conversation with the sponsor, and not all of those issues have been resolved. And so I would, in that case, like to hold the bill until our next session in order to be able to make sure that we have the language correct.
Sure.
Representative Warren.
Oh, I was gonna ask for that motion, and I would second it if it's been made.
Yeah, we don't need to have a vote on that. This is a language review, so we'll just make sure that the bill sponsor is satisfied with those changes. It seems like that, and my opinion is that is a substantive change, striking those words, in my opinion. And so if we do strike those words, we will have to reconsider our vote for the majority report. Moving right along.
Okay. So the next one that I have is LD 319, which is the other divestment bill. And I will share my screen with you on that. Unless there we go. Just say it froze up on me. So this one was majority ought to pass as amended, minority ought not to pass. This one didn't have any recommended changes or considerations from the main retirement system. The treasurer's office did recommend, because the intent of the bill is to divest or not invest in for-profit prisons. And so my understanding in getting correspondence this morning from the Office of the State Treasurer is that they feel that perhaps the definition of a for-profit prison would be preferable or helpful. I will say I don't know the extent to if that's necessary. It has been proofed several times, and I understand that Treasurer Beck just joined, so if he wants to potentially sort of further describe what he thinks should be for a change, but it wasn't flagged during the proofreading of the bill, so I don't know to the extent that it's was seen as necessary in the internal processing. But other than that, this bill is ready to be reported out. It does have a fiscal note attached. Additional costs can be absorbed within existing budgeted resources. So I'm happy to try to answer any questions on that. Or
thank you, Mr. Langland. Thank you, Mr. Langland. I didn't mean to cut you off. There's a delay here. Treasurer Beck, if you are here, I thought you came in. Please turn on your video, introduce yourself. There you are.
Senator Hickman, Representative Sylvester, can you hear me and see me?
Yes, sir.
Yes, your analyst described it accurately. We did flag sort of our preference for a tighter definition. The fact that Maine PERS did not flag it gives me some comfort with the current draft. It's our fault for not testifying initially on this bill at the hearing. Certainly would not be opposed to the tighter definition that we offered your analyst in the memo sent this morning, which I hope you have.
Thank you, Mr. Treasurer Beck. Are there any questions for him? I would like to see the language that is proposed on the screen, please.
Okay. Yep. 1 second. Let me pull that up. I think that I sent it through an email, but I know.
Well, I just haven't read it yet.
Yeah. Well, I know how things get lost in the virtual world. So let me try to find that. Okay, so I will share my screen with you.
Thank you.
Yep. Okay. So it says we suggest a definition that reads corporation or company that has as its core business the operation of prisons for profit. And I would say that does seem to fit sort of where Maine PERS recommended the fossil fuel definition changed in LD 99, but obviously it's the committee's discretion how to proceed.
I see. Yeah, I am a fan of definitions being as clear as possible. Representative Warren.
Do we know, I'm sorry if I've missed it, do we know what the sponsor is interested in?
I don't believe that I don't believe that we know for a fact what the sponsor thinks, but I can just say, since the bill is in the possession of the committee, that making definitions as clear as possible is always the goal of writing the law. And this actually makes, in my opinion, a clarifying definition, because instead of saying that owns or operates, it says has as its core business the operation of prisons for profit. That's just a clearer definition for me on being on the report. So, Representative Pebworth.
Thank you so much, Mr. Chair. If I were a corporation and I just had a tiny little bit of prison for profit in my business portfolio, let's say, does the new definition exclude me?
And you are asking that question of, I mean, Treasurer Beck, I'll first ask you to take a stab at that, since this is your definitional change suggestion.
Sure, and I think Representative Pebworth's question illustrates that it is essentially a policy decision for the committee. But out of an abundance of caution, when we discussed this internally, and also with some private firms that actually specialize in these sort of transitions, we just wanted to be sure that the intent was not that we divest from, say, a corporation that happens to provision certain supplies to a prison for profit or food or that kind of thing. There are, based on our review, very notoriously 2 publicly traded companies that have at its core the operation of private prisons. That's clearly the intent of the bill, to target those stocks for divestment. But we made sort of the assumption the committee did not intend to require we divest from any corporation with any book of business, no matter how small, related to the operation of private prisons. And I do not know the sponsor's position. We did share the memo with the sponsor beforehand.
Representative Pebworth.
I appreciate this large bite of the apple and will pursue large bites of smaller apples at another time. Thank you very much, Treasurer Beck.
Anyone else on the committee? Great. So I would simply suggest, since I'm on this report, that, Representative Warren, there you are.
Yeah.
Sorry about that.
Thank you. My understanding is that the for-profit private prison industry is in some ways a growing field, and I have a lot of concern because I do think that this shift is a pretty meaningful change. And in the previous bill, we were waiting to know where the sponsor is on one part, and I guess I am interested for the same reasoning, and in part because on both bills, I have issues with the change, which I think is pretty serious and not about the investment in private prisons, but about the background of the business itself. And I think our issue and the intent behind this bill is about us profiting off of a private prison industry, not like the character of the business itself and the size of that business and other things that it does, just that we don't want to be investing in companies that invest in that way. That's my feeling. So I feel it's significant, and I don't think it's the same as the intention with respect to the treasurer. And so I would oppose it. And I'm also, again, interested in waiting to know what the sponsor believes, if they want to comment in the same way that we did with the last bill, if it's possible. Thank you very much.
Chairman Sylvester.
I am endeavoring to reach out to the sponsor, and so maybe we could move on to the next one while I do so, and we could revisit this.
Thank you. Thank you, Treasurer Beck. Have a great weekend. Mr. Langren? What's
Yep.
next?
Next up, we have LD 543, which is an act to provide that the minimum wage increases by the cost of living every 3 years. It was majority ought not to pass, minority ought to pass as amended. So the amendment incorporates the fiscal note. And here's the fiscal note.
Thank you.
There are
And
no
the
questions.
minority
Sorry.
report. That's for the minority report, correct? This is the language review for the minority report, correct?
Correct.
Okay, so Senator Garin or Representative Morris, if you are here, can you just give us the thumbs up or the thumbs down on this, please?
That's fine.
Thank you. Moving right along.
Yep. Let me get the next one. So the next one is LD 654, which is an act to create a 24-hour shelter capital project funding program. It was majority ought to pass as amended, minority ought not to pass. And there is a little typo, so it's not 100% final, but it's final enough not to change the substance. This is the majority report, $3 million. If you recall, this was passed basically as written, but there was a strikeout because there was language that said the funding had to be used within existing funding formulas, and Maine Housing recommended that that be taken out. And so that's what the majority of the committee voted to do. And here's the fiscal note that sort of reflects the allocation of $3 million.
Thank you.
Mm-hmm.
That looks good to go for
Okay.
the minority report. Thank you.
Mm-hmm. Let's see. So the next one is LD 773, which is an act to assist public school students and families who are homeless. It was majority ought to pass as amended, minority ought not to pass. This is Representative Brennan's bill. Sort of adds an appropriations and allocation section. And here is the fiscal note for that. And this is the majority report.
Thank you.
Mm-hmm.
That looks fine from my perspective.
The next one is LD 824, which is an act to extend the protections provided to state employees upon the expiration of labor contracts to other public sector employees. Its majority ought to pass as amended, and minority ought not to pass. The majority report is actually straight ought to pass, so this is just incorporating the fiscal note. So it's technically ought to pass as amended. And here's the fiscal note.
Thank you.
Mm-hmm.
Any questions? That looks great.
The next one is LD 838, which is an act to exempt substitutes, coaches, and temporary employees in the education system from paid sick leave requirements. It actually changed the title, so now it's going to read an act to exempt certain employees from earned paid leave requirements. It was majority ought not to pass, but minority ought to pass as amended. So if you recall, this amended the bill to and sort of really defined somebody who works in a school as a substitute teacher for less than 60 days is not eligible for the new earned paid leave law that went into effect. It also defines coach and temporary employee for that purpose. In subparagraph 2, I did want to flag for the committee because I had some further discussions with the Department of Labor. And And so it says a volunteer or a person who is paid a stipend by an employer or who works for an employer on a per diem basis, which my understanding is that this language was fine when it was voted in committee, of course, but it might not intentionally be broader than the minority report intended. I don't know. So it could potentially exempt healthcare employees or other part-time employees. It could sort of, the department had a concern that, and I don't know if they're here, but potentially, nothing would stop an employer from classifying a part-time employee as a per diem employee, which would make them exempt. But the subparagraph 2 is added because, if you recall, there were 2 bills, one of which was from Representative Greenwood, but this one was from Representative Poirier. In this one, she wanted to address the municipal employees that, like such as election clerks and firefighters, that sort of were paid a little bit irregular. They didn't have specific hours. So that was the intent of subparagraph 2. And it still does that, but it might be broader than the committee intended. So, or I should say the minority intended. So I just wanted to flag that for review, but if they're okay with it, then it's certainly ready to go.
Thank you, Mr. Langland. Senator Garin, Representative Drinkwater, any comments, concerns?
Seems fine with me.
Great.
And it does have a fiscal note attached.
Yep.
So the next one is, let me share my screen with you. LD 1047, which is an act to create an alternate minimum wage applicable to student employees who are under 20 years of age and to employees who are under 18 years of age. So the title actually changes to an act to create an alternate minimum wage applicable to employees who are under 18 years of age. So it really just strikes very specific parts in the bill. In this, I should back up and say that it was majority ought not to pass and minority ought to pass as amended. If you recall, Representative Bradstreet made the motion, and one of the things that he wanted to do was change the age from 20 to 18. And so that's essentially what this amendment does.
Is that okay with the minority report?
And
That's
there is,
fine.
and there is a fiscal note.
Great. Committee members, beloved committee members, I'm going to go check in on VLA right now. I've just been called in for a quorum vote, I believe. And so with that, I want everyone to have a great weekend. I will turn the rest of the language review over to Chairman.
Mr. Chair? Mr. Chair?
Yes, Senator Garrett.
The other chair. I sent you a private message that I had made a mistake and voted not to pass on 1453 Representative Bradstreet's bill, and I had wondered if we could reconsider that at some point.
I saw the private message, and quite honestly, I'm thinking about it, given the fact that it's the second time, and given the fact that we get, as I had said, we had reconsidered a previous vote that you'd also voted incorrectly on.
No,
Yes,
no, I was restarting my computer and didn't vote on the other vote because
no,
my
we also
screen
had
got
one
full.
where because I
I
said
never
quite
changed my
clearly.
vote. I never
said-
changed my vote.
Well,
I
okay,
did not
then
change my vote.
then we're going to stay with where we are, because I guarantee that you did, because
Sure.
I tried to make sure that you were giving the correct vote while it was happening. Thank you. Go ahead, Mr. Langland.
Sure. So the next one is LD 1279, which was majority ought not to pass and minority ought to pass, which, since there is a fiscal note required, changes to ought to pass as amended. So the amendment just incorporates the fiscal note, and the bill is an act to increase the minimum wage. And here is the fiscal note.
I'm sorry, this is the majority?
Minority.
Minority.
Yep, Yeah, Representative Collins' bill.
Is the minority report fine?
This is the,
Oh, this is the majority.
yeah, this is the minority. Yeah, sorry.
Yep.
Okay.
I'm gonna pause you for a second. Senator Garin?
Yes.
So I was a little terse because I was trying to explain something. I'm certain that I was correct about that, but I am going to make a motion as you were on the prevailing side. I'm going to make a motion to reconsider, and we'll let the committee vote on whether they would like to do
Okay, and I would just say, go back and check the tape. I never changed my vote before.
I would be happy to do that, but I honestly remember it very clearly. Thank you. The motion to reconsider. Is there a second? There is a second by Representative Warren. We call the roll, Ms. Thompson. Motion to reconsider on LD 1453.
Senator Hickman is absent. Senator Guerin.
Yes.
Guerin, yes. Senator Marymount. You're muted, sir. Hold on. I'm asking you to unmute. You should see a little message, hopefully.
Okay, yes. How did I vote before?
We're just voting to reconsider. You, it was a
thank you.
majority report and Senator
Yes.
on Representative Bradstreet's bill.
Was that a yes?
Yes, please.
Okay. Marymount, yes. Representative Sylvester.
Because I always vote yes on these, despite other votes, yes.
Sylvester, yes. Representative Bradstreet is absent. Representative Cuddy.
Yes.
Cuddy, yes. Representative Drinkwater.
Yes.
Drinkwater, yes. Representative Gear.
Yes.
Gear, yes. Representative Morris.
Yes.
Morris, yes. Representative Pebworth.
Yes.
Pebworth, yes. Representative Prescott is absent. Representative Rader.
Yes.
Rader, yes. And Representative Warren.
Yes.
Warren, yes. That is unanimous of those present.
Excellent. I would open the work session. We are reconsidering LD 1453. Is there a motion on the floor? Representative Gear.
I move ought not to pass.
Motion is ought not to pass. Is there a second? Representative Rader seconds. Is there any discussion on the motion? Seeing none, Ms. Thompson, if you could take the roll.
Senator Hickman is absent. Senator Guerin.
No.
Guerin, no. Senator Marymount.
Yes.
Marymount, yes. Representative Sylvester.
Yes.
Sylvester, yes. Representative Bradstreet is absent. Representative Cuddy.
Yes.
Cuddy, yes. Representative Drinkwater.
Nay.
Drinkwater, nay. Representative Gear.
Yes.
Gear, yes. Representative Morris.
No.
Morris, no. Representative Pebworth.
Yes.
Pebworth, yes. Representative Prescott is absent. Representative Rader.
Yes.
Rader, yes. And Representative Warren.
Yes.
Warren, yes. That is 7-3 with 3 absent.
7-3 with 3 absent, the motion carries. Mr. Langland, if you close the work session on LD 1453, Mr. Langland, if you would continue.
Was the minority report still ought to pass?
Any of the minority who are listening, is it ought to pass?
Could you repeat the question?
Is the minority report ought to pass?
Yes.
Okay, thank you. That actually concludes the language review that I have with you, but Ms. McCarthy-Reed has, I think, several as well. So you're not done yet.
Perfect. Welcome, Ms. McCarthy-Reed.
Thank you.
Thanks for being with us. We love to clear these off the deck.
Sure, yeah. I have 6 of them to share with you. For bills that you previously voted, most of them are fiscal note onlys, except for this first one, which was LD 620. This was the bill resolve asking for a study to develop a plan for teachers to collect Social Security. This is the majority report of the committee, and it just changes the date for Maine PERS to submit the report from December 1 of 2022 to December 1 of 2021. This corresponds with the other bill that you are considering, which would require Maine PERS to do a broader study of developing new plans that would conform with Social Security. And that date is 2021 as well. This one is more of a narrow focus on teachers. It just changes that date. And then I wanted to share the fiscal note that additional costs to Maine PERS to implement the requirements can be absorbed within their existing budget.
Thank you so much. Is that fine with the majority? It looks fine to me.
Great.
Seeing nodding heads.
Great. Let's move right along. The next one is LD 1105. This is the broader study that I just mentioned that would direct Maine PERS to convene a working group to investigate public pension options. No fiscal note required on this. This is also a majority ought to pass report. So it will just go out as straight ought to pass, and the minority was ought not to pass.
Thank you so much.
Sure. That looks good. I'll keep going.
Yes, please.
Sure. I'll skip over this one. The next one is LD 956. I've noted here ought to pass as amended because there will be a required amendment to add a fiscal note. This was a majority ought to pass as amended report, but the change will simply be adding the fiscal note and providing the necessary funding. The minority report was ought not to pass. This is the bill that would amend the eligibility criteria for creditable service in the armed services to add some additional periods of time where folks may have served in military service, and this would allow them to buy sort of subsidized credit for that time in military service. This was a bill that was considered last in the 129th legislature. At that time, it had an unfunded actuarial liability of 4.9 million, and it's consistent with the preliminary fiscal impact statement that you received on this bill. So if it moves forward, it will be referred to the special appropriations table. There will be an amendment drafted to provide the appropriation of those funds.
Thank you. Are there any questions from the majority? Seeing none.
Great. This next one is again an ought to pass. Majority report ought not to pass. Minority report. This bill would increase the amount to which state employees or teachers retirees cost of living adjustment is applied from 20,000, which is what is currently, to the retirees' actual retirement benefit. This will necessitate a fiscal note. I think we talked before about the significant unfunded actuarial liability to provide the cost for this legislation. If it moves forward, more than 900 million to account for that unfunded actuarial liability. So it has both a fiscal note and then it will also require an amendment to provide the appropriation of those funds. So if this bill goes forward, again, it will also be referred to the special appropriations table for further consideration of the funding requirements.
Okay, thank you very much for that.
Sure. The next one is LD 190. This was the bill that related to the reduction for certain corrections officers that are currently included in the 1998 special plan. It would allow all of their years of service to be included as if it was service under the 1998 special plan. This is the majority report. It would add an appropriations and allocation section to provide the necessary funding. This is a bill that was considered last session, but because of the passage of time, the unfunded actuarial liability actually is reduced a little bit from your previous legislation. It's approximately $280,000. And again, this would be referred to the special appropriations table.
Okay, perfect. Thank you.
Yep. And then the last one is LD 1101. This would add civilian employees who work for the Computer Crimes Unit in the Department of Public Safety and the Computer Crimes Lab to the 1998 Special Plan. The way this bill is drafted, it's drafted prospectively, so it does not have any unfunded actuarial liability. It would provide eligibility for those employees of the Computer Crimes Unit that are hired on or after October 1 of 2021, and it would allow existing employees to make a one-time election to join the 1998 Special Plan. But because it's prospective only, it doesn't have those associated unfunded actuarial costs, does have a small fiscal note. So there will be a need to provide appropriated funds to add these employees. It's split amongst the different units, but you'll see those amounts here. And this bill, if it moves forward, will go to the special appropriations table as well. It's a total general fund appropriations of about $24,000 in the first year of the biennium, and it doubles approximately in the second year of the biennium.
Thank you.
Sure. The one thing I wanted to mention additionally with regard to LD 1101, I know that at the time that the committee took the vote on this bill, there was a suggestion about adding an additional amendment to include employees of the Office of the Medical Examiner's Office, either as part of LD 1101 or as part of another piece of legislation that the committee was considering. And I did want to, we asked for some financial estimates from the Office of Fiscal and Program Review to do that on a prospective basis. And I just did want to report that back to the committee if you're interested in sort of considering this issue further. But to add the employees to the 1998 Special Plan prospectively, it would be approximately $20,577 in FY22 and $21,167 in FY23. And all of those positions are currently funded with general fund dollars. So I just wanted to report that back to the committee.
Thank you. Is there any discussion about that? Representative Cuddy.
Less discussion, more just, could you say that one more time? My Zoom fatigue brain
Sure.
is just really hitting on like a single cylinder right now. And it just, for whatever reason, I couldn't follow what you were saying.
No, that's fine. You had talked at when we, there was a suggestion made at the public hearing on the bill related to employees of the Computer Crimes Unit and adding them to the 1998 Special Plan. You had some testimony from an employee in the Office of the Chief Medical Examiner asking for the committee to consider adding those employees as well to the 1998 Special Plan. And while the committee's vote was just to move forward with the bill as originally drafted, we would ask for some additional information about what the potential costs of adding the Chief Medical Examiner employees to the 1998 Special Plan would be on a prospective basis, so it wouldn't have the an unfunded actuarial liability associated with it. And the estimate that the fiscal office provided indicates that it would be, if you did move forward with something like this, would require general fund appropriation of $20,577 in FY22 and $21,167 in FY23.
Thank you very much for going through that again. I appreciate it.
Sure.
But the bill, the way we passed it, did not include those folks. Is that correct?
It does not, no.
All right. Very good. Is there any other discussion on that? Everyone, is the majority good with that? All right.
Did we have, Mr. Chair, do we have consensus that we wanted to add? Was that a consensus decision before that we wanted to add those folks?
I believe the way we passed it was not to add them, Representative.
That's my recollection as well, but to have some additional information about the potential fiscal costs if you did want to think about adding them now.
Thank you.
And also to consider as we consider the larger group of folks who got left out and for various reasons.
Yep, and you do have some carryover, but you have some carryover bills that you've identified for carryover where for additional consideration of retirement issues. I suppose you could defer this issue to further consideration as part of that as well.
Thank you so much for your work, Ms. McCarthy-Reed. We appreciate getting these off the deck.
You're welcome. That was it for me.
Perfect. I think that then concludes our work for the day. I want to thank the committee for being here and for all your great work. Unless you have anything, Mr. Langland? Very good. Have a wonderful weekend.